Hello, my friends. Thank you so much for allowing me to uh, talk to you about what's going on in my life. From being essayed by my therapist, a doctor who is now dead. No one ever told the court, nor did they tell me, which is unlawful because you can't sue dead people. So even in litigation, it's called a substitution. You have to substitute the estate. And so in the instance of Dr. Islam, there was an estate. So if you can just hang with me, it's going to be going back and forth a little bit, but we're going to get there. So when I found out that he was dead in April, I filed 3 motions. Motion for substitution, which would have been his wife because she set up the estate in November 2024. So she set up the estate. I didn't know that until April, that he had died, and I didn't know that she had set up an estate. But the most important part was that his attorney, by the rule 25.01, I can cite that rule, Tennessee Rules of Civil Procedure, that the attorney, was supposed to inform the court, number one, number two, myself, or anyone that found out that he was dead. Well, guess who found out? It wasn't the attorney was going to tell the court. I did. When I told the court about the death of Dr. Shahidul Islam, I want to get his name right, and that the case needed to be remanded, opened, sent back, stopped, what are all the words that it takes in legality, that at this point, that the ruling that was affirmed can't be affirmed. First of all, you do the substitution, you bring the wife in. Oh no, you don't want to bring the wife in because they came for me extremely hard. Why? His wife, being of their faith, must never know anything about her husband, that he essayed his client. How do I know that to be true? When I was in the lower court, I tried to bring her in because she was the owner of the company. She worked for the company. And I had an affidavit of another patient who testified. The court said no. I got sanctioned for $11,000 some for that because I had sent the information to her. I was serving her process. I was serving her the complaint, but I got it because the court said you can't do that, and she's not a party. How is she not a party? He said, well, you should have looked it up before you sued her. You can always amend a complaint, but you didn't want her. This doctor did not want his wife to know what he had done. How do I know that to be true? It's in the deposition that I deposed him in. So with that being said, so this past Saturday, Memorial Day weekend, I get a letter from the court. Your case has been mandated. Mandated means closed. How can you close the case? I got 3 motions before you. 3 motions saying that he died. 3. Little did I know, I'm looking at this mandate. I was like, oh my gosh. So I felt in my sanctified soul, they were on because they knew about me posting on TikTok. They're following me, which is okay. I'm not saying anything that's illegal, nothing to defame their characters. This is all public record. So in the mandate, I had to pray about it. I was like, okay, I know for sure that if you have 3 motions in the Court of Appeals, why would they have closed this case out without adjudicating all motions and all of the record? Let me speed it up. So what did I do? Prayed about it. So I wrote up 2 motions. One motion was to remand the case back to the Court of Appeals and to resolve all issues of relief or rehearing. Number 2, I filed a motion for stay in the Circuit Court of Appeals. So mind you, this is 2 separate courts, separate laws, separate rules and regulations. So I'm racking my brain all weekend to get this done. This today, Monday, I did get it completed. Monday morning, 8:25, my phone starts to go off in emails. notifications. Your case has been mandated. Text and cost has been sent to your next email. Then the next email was like from mandate to all taxes and costs assessed to the plaintiff. That would be me. Well, they didn't know that I had the motion to stay, which means that the lower court can't do anything until we resolve the issues in the Court of Appeals. Now, what's going to happen in the Court of Appeals? Who sent me this letter was a deputy clerk by the name of Jim Heavener. He's very close friends with Mrs. Longmire, and I'm going to prove that. When Ms. Longmire and I when I filed to go to the Supreme Court, I filed an application 11. That's what it's called. You have to file an application. You just can't go to the Supreme Court in Tennessee or any place in the States. So I filed the application. It was denied. But let me go back. When Ms. Longmire missed the deadline, she said she didn't. But she did make a quote in there. She said, Mr. Heavener called me and told me to put case law in my brief or in my response. Mr. Heavener is the deputy clerk for the Tennessee Supreme Court and the Court of Appeals. And if you're not of the Tennessee Supreme Court, forgive me, I gave you too much accolade. But the fact is, I have it in writing. I addressed him in an email too, which I'm going to publish tonight. I'm going to publish also the letter that Mrs. Longmire's response to the court. It's not a suggestion. He told her what to do. No clerks are supposed to give legal advice. None. Not leading, none. So what does that mean? I'm going to show you now the relationships that they have behind our backs. Yes, behind our backs. And does it make me furious? Yes. Because that's the way they get rid of you. And when they don't like you, they get rid of you. They plan and plot. The question is, who are the they? Put two and two together. Right now, I can say for sure, when I show you all the evidence in the next two videos, you will see, you will see one letter of response, and she names him. She said, he called me. He called her. Mr. Heavener called Ms. Longmire and said, please put these published or unpublished cases into your filings. That's case law to allow you to win. You win based upon case law, whether published or unpublished. Whether it was published or not published, it shouldn't have happened. I'm a pro se litigant. But Ms. Longmire put it in there because she knew she was going to be struck down. This is what I do know for sure. That my name in this case means nothing what happened to me. They're trying to get rid of me because the facts are true. And the law has been true. I have been put out of the Court of Appeals and the Tennessee Court of Appeals. Per quorum means all of them did not like me. And then they won't address the issues. The man is dead. And then you still rule. And I have to file a motion to stay. I've talked to numerous of lawyers. And this is something that shouldn't have happened. I've gotten case law now when I filed it. Now I want to see what the Court of Appeals is going to say. Now I want to see if the judge is going to allow a stay or keep going and say, okay, because the only reason they're doing this is they don't want the wife to know who the husband was.